Can you assign a certificate of sponsorship to an individual whose permission has expired, who is an overstayer, or an application has been rejected as invalid, or they are on immigration bail? I'm going to address this question today. To begin with, I will, as usual, I start with our new service which we started about 3 months approximately now, and priority slots. We obtain priority slots on behalf of employers. So first priority slot approval, there are three of them I will share. Two came today and yesterday it was one. So today's one was Wednesday 26th August 10:31 a.m. The approval is on your screen now. Anyone wants to do any investigations? Yeah, so you can do that, or if you want to apply form, link to the form will be in the description. Okay, coming back to my point about can you assign a certificate of sponsorship. So it is in the guidance, and the guidance has been updated also, like I think this week or so, last week only or something, very shortly. So I wanted to address this point. I'll go to the immigration bail part first, beginning with if your application is rejected, which is a very common scenario. Home Office is taking a lot of time to approve certificates of sponsorships, even for extensions. Forget about new hires completely. Even for extensions of someone who is already working, already paid proper salaries, everything compliant, still Home Office is taking time. So this is a common scenario that is happening. You file an application without a CoS, pending CoS strategy, which is when we try to request Home Office to keep it on hold, and at some point Home Office rejects the application as invalid, because that is this is a requirement of the immigration rules. You should, on the date of application, when you submit the skilled worker, care worker, any healthcare application as well, then you need to have a certificate of sponsorship which has been issued to you within the last 3 months, which is not the case because your employer has not got the allocation. How will they assign it to you? You file it without a CoS. At some point, Home Office stops and they do reject your application. It's a very common scenario. Hence, I wanted to address from this point, and I'll go towards immigration bail. So within 14 days of that rejection, you can file another application, which will be out of time. You will not have a right to work in the UK from the point when the first application is rejected. Very important. From that point till a decision is made on the second application, you will not have a right to work. So once you get the CoS on the second application, you update it. Today only it is a care home situation where I think they tried to file it themselves. It was rejected. We made sure now we get the certificates of sponsorship, the CoS allocations. I think for the employer, about 20 of the CoSs I think they got approved now, and one of them they assigned it, and today we sent it to the case working team for a particular migrant who had filed an application by himself that was rejected as invalid without a CoS. Within 14 days, we came in, we filed within 14 days another application which is out of time, and he stopped working since then, and now we've sent the CoS. So yeah, that will be processed. So this is what is allowed in the immigration rules. I'll share the second screenshot of the priority slot CoS approval. So the second screenshot is on the screen. Wednesday 26th August 11:15 a.m. We've redacted the client information, but this is what we are doing for all the clients. It's a simple form. The link will be in the description. You just provide the details of the sponsor license, name, number, the date the CoS was requested, whether it was annual or in year, and I think that's it. And from there we take it on, and we have 100% chance of success. Usually within 24 hours up to 72 hours we get all our priority slot requests that we make. So today we got two, and yesterday it was one. Okay, coming back to my point. So yes, it is possible. Even if your application is rejected, you can file an application within 14 days of that rejection, and then once you get the CoS, you send it to them and get a decision. The only problem is from the point the first was rejected till the second one is approved, you don't have a right to work. Important thing. This applies not to the main applicant, even to the dependent. If they are also refused, exactly same things apply. They are refused, they don't have right to work in between, and it starts again when their permission is approved. Important point about immigration bail. This is the latest point that is changing the last 3-4 months. This is in discussion. Till last year or till this change came in, what was happening was people were filing these FLR applications. Hence, about 1.5-2 years back, 1.5 year back, I think December or so, when I had also made several videos where I said, don't file those FLR applications. Finally, you go to immigration bail and you have to leave the UK. I had seen all of those refusals where people filed it themselves or through other lawyers or something, consultants. they got refusals. After that also, some of them tried skilled worker visas, which were rejected. I had seen all those refusals where people used to always have consultation. Links to the consultation will be in the description. Yes, so that's what I'm addressing. That problem, when anytime anyone was put on immigration bail for whatever reason, mainly it was for the time buying application FLR, which would cost, currently it costs about £4,000 per applicant. Even if you file that, after that, if you get a refusal, usually you get a refusal after a certain point of time, and then they put you on immigration bail. That was the only rule that was not in line with the section 39E at that time, and currently it is called SUI, suitability 13.1 ABCD. There are some things, so not being more technical. So what 39E or SUI 13.1 means, within 14 days of any problem event, so let me just term it as problem event, which means either a refusal, rejection, administrative review, end, lapsing, etc., etc., your rights come to an end. Think of it in that way. A section 3C stops at some point. Uh, Within 14 days of that problem event, you were allowed to make another application, though out of time, which is the first part I explained. Now I will share the third screenshot and continue. This is the approval of the priority slot from yesterday, Tuesday, 25th of August, 9:57 a.m. It will be on your screen. Anyone wants to do investigations, it's real and all, so you can see that. Okay, continuing with the point about section 39E previously. Now SUI, suitability, yeah. SUI, it is named as 13.1. That is the section ABCD. There are different parts in that. So summarily, I'll explain in simple terms. Whenever that problem event happened, rejection of an application, refusal of an application, uh, refusal of admin review, refusal of appeal dismissed, anything, your section 3C comes to an end. That is something I would call it as a problem event. I am naming it. And only one problem event was not a part of that. And that problem event was immigration bail. That was the only thing that was not in line. So immigration bail was somewhat outside. If you are put on immigration bail, you don't have this 14 days protection, and that did not make sense. Hence, Home Office brought that in order. They picked up that immigration bill, which was completely sitting outside this section 39E. Previously it was called as section 39E. Now it is come under part suitability 13.1. So that immigration bill has been picked up and has been added over here. So think of it that way. They haven't added it, but that's how I would interpret it. So that this protection of a problem event, one of the problem events can be immigration bail. You file a FLR application, which is the common scenario, and where people are put on bail, Home Office refuses and they put you on bail. Previously, you were not allowed to file any applications. People would file, they would get refusals. I have seen reviewed many such refusals. And now that is only changed, where that has been brought in line with other areas also. That is also a same problem event. So the problem event can be a refusal or rejection of an application, etc., or it can be refusal plus immigration bail. So it's not just, you don't just go on immigration bail. Usually something happens, application is refused and then they put you. So even if you are on immigration bail, within 14 days of you being put on immigration bail, you can file a valid application. And important thing for the employer side, employers have a problem. They always say, I've seen this very commonly. I have consultations and then people will ask me, oh, employer is saying whatever that section 13.1 that you're telling me, I'm telling them, they don't want to give you a CoS. They want to do a share code check. Share code check may not give you anything. If someone is on an immigration bill, share code check will come negative. It will say you don't have a right to work or something, or nothing will come up. So that is not going to help the employer. Hence, it is very important, if you are an employer, HR person, or an applicant, whoever you are watching this video on any channels, very important, if the individual is on immigration bail, nothing will be seen on the digital system. You will have to take the documents that everything was filed on time, when the refusal came, when was the new application filed, and assess from that. For those things, yes, employers and employees, everyone comes to me where I check and I can confirm saying, yes, it is possible. You can assign a CoS or go to any other lawyer. So for that matter, so someone will have to look at the things and tell. No one at Home Office will tell you this, but this is by operation of law, because the new thing has come in. If you check someone who is on immigration bail, they will have no right to work, nothing. There will be no share code, nothing on the digital system. Your visa has ended or something, whatever it will say. You don't have a right to work. Also, that also happens similarly when, in my previous example where I said application was rejected or refused. As soon as any application, admin review, anything, your section 3C comes to an end, on the digital platform, you may highly unlikely you will get a share code. I don't think you will get a share code with any of those matters, whether application is rejected, whether refused, administrative review is refused after the application refusal, appeal is refused, whatever. So anytime your section 3C comes to an end, on the back end, which is what employers do, I know every HR asks this, give me a share code. Clients just keep on asking me, I this, then we have to explain it to them. No, you will not get a share code because this is your status. You are an overstayer, but your only one application which filed within 14 days of this problem event, as I defined, it is protected by the law, where Home Office will ignore this for the purposes of a decision and make a decision as good as you had some permission, you had a visa, you were not an overstayer. But that does not change the back end of the Home Office. They only see the application when it comes to them. So you will not get a share code. That's very, very important. This is another thing I wanted to address also in this point. But employers can assign a CoS. So in the employers guidance I was looking, there is a change that I was reading through today. So I thought of addressing this point. Applying from inside the UK, permission to stay. If it is, this is the guidance to the employers guidance. Section S 7.7, 7.8. That is where I'm saying, if the person is on immigration bail, you can assign him the CoS provided you are satisfied that he meets the exceptions for the overstays, which means he is in that protected area. So as I said, a problem event happened, within 14 days you filed the application. That is exception for overstayers. So that is important, and it applies to everyone whose section 3C leave has ended. Whether you're put on immigration bail or not, that's a separate event. But the point is, if your section 3C leave has come to an end, which means you don't have right to work in the UK, still, if you have filed an application within 14 days, I know I'm going in circles, but I'm trying to explain. I know people don't understand. It is a tricky one. You can still make an application and an employer can assign you a CoS. That is the important thing. People file the applications. When they go to the employer, I have seen so many of them. They are in the pre-employment checks. I have this consultation on a daily basis. So the links will be there in the description. So what happens, all the applicants, they tell me, oh, I'm already in discussions, I'm halfway through, they've done all the checks, they are just about to give me a CoS, and then they say, oh, I need a share code. You will not get a share code because you are an overstayer, but they can assign you the CoS. That change has been made especially for immigration bail. So other things were already there, the SUI 13.1 protection, but this immigration bail part has been added. That's why I was reading it again. So that's what just occurred to me of thought of explaining that. If you're an employer, yes, you can assign someone who is protected by exception for overstayers, section SUI 13.1. That's how we call it. So if you are protected, then the employer can assign. If you are protected, you are only protected if you file within 14 days. So that is going backwards. Yes, your application will be considered for a decision and that overstay will be ignored. The application will be decided on its own merits. Home Office may research, interview, do all those things, whatever they do on a normal in-time application. But that's a separate thing. The point is, if you haven't filed, if you don't have the protection of this exceptions for overstayers, SUI 13.1, then Home Office will just refuse the application without going into the merits, whether you qualify or not, whether you have a CoS or not, whatever that is. They won't even look at that. If it is beyond the 14 days, if you don't have the protection of this particular exceptions for overstayers, Home Office is not going to decide the application. They will just straight away refuse. They won't go into the merits of the case. So that is something important. I've shown all the 3 priority slots. And what else? If you want to book a consultation, links will be there. Subscribe to the channel. Yeah, I see many people watching the video. The views are high, but yeah, subscription maybe people forget. Subscribe, follow, whatever that is you do on your particular social channel. So do that, and links for the consultation will be there. Second link which I'm commonly putting is where employers are getting information request, and we have drafted an exhaustive documents list and information list which employers should prepare in advance, be ready before that request comes to from Home Office. Almost 80-90% times Home Office does ask for that extra information. So that link I will put, consultation link and the priority slot link which I was advertising in between. So yes, we are getting priority slots. So what is this priority slot service? Home Office, if you ask for a CoS allocation, CoS request, whether annual, in year, or any priority change of circumstances, name change, address change, anything like that, authorizing officer change, level user change, legal representative change, anything. So all those changes and several others are a part of the priority services. What that means, under the standard processing, it just goes and sits in the queue. After about 16 to 18 weeks, Home Office picks it up, around 4.5 months approximately, and then they send the information request, and then it goes further and further, and more delays till you get a CoS. Hence, to to solve that problem, Home Office has a solution, but that solution is a hit or miss. So I'm coming to the solution part, where you can request the priority slot. Every day there are about 100 slots, maybe 5,000 employers asking for it, or maybe more. I don't even know. I think it is definitely over 1,000. I know that. So they request that priority slot to get that particular, either a cost allocation request mainly, or any other request, to get it considered, picked up for a decision and looked at it. That's called as considered for a decision. A caseworker picking it up, not approving it. Important. So just to pick it up, Home Office has this priority service. If you get that slot, priority slot, then you pay £350 of Home Office, and they look at it within 5 working days. And instead of after 4.5 months, they asking for that additional information or approving your costs, they approve also. I've done many of them where we do get approval. Last week I got one, I remember. So without even asking for the additional information. So that decision is, they will do it now within 5 working days. They try to do it. I've seen that, because yeah, if you need representations for that also, we do that, where we log into the system and apply on your behalf for any extensions. There is specific information on the extensions the Home Office needs: cost reference number, previous information, anyone who is already on sponsored by you, their proposed salary, etc., whether transition provisions apply to them, etc., etc. So all those things are required to be put. It helps with getting an approval quickly, because I remember last week only we applied. Within about 4 or 5 days or so, the employer straight away got the approval also. We got the slot, submitted, next day we got the slot. Within about 3 to 5 days, I think he sent me the approval. I saw that. So yes, it is possible to get the approval without that additional information request also. So that additional information link also I will put, what they ask for. You can prepare in advance. It helps just to do an audit of your organization, and if Home Office asks, you can just throw it at them and give it to them. So consultation link, that additional information link, and what else, and the priority slot link. Yes, it will be there. And yes, like, subscribe. Thank you very much for watching this video.